Issues at Hand on Family TV, enriching lives.
Thank you for joining us on Issues at Hand, and we are very, very excited indeed to have you along this ride. Now, Issues at Hand is a program where we have very, very pertinent discussions indeed when it comes to different issues that are happening in our societies, and we always have a guest who takes us through those discussions as we try to find solutions for those issues in society. Now, one of the issues we have as citizens of this country is that we do not know different facts. One, do you know that we have three arms of government? Well, these three arms of government include the executive, the legislative, and the judiciary. And today on Issues at Hand, we are going to go through the judiciary, its mandate, and we want at the end of this program, we want you to understand and no longer fear going to court. We know many of you fear stepping inside the court. You want to know what happens during a court session, how to set up a court case, and how it happens, and what happens inside a court. That's why today we are going to discuss all things judiciary. Now, my guest today is a member of the judiciary indeed. His name is His Worship Jamson Kalemani. You are very welcome to Issues at Hand. Thank you for joining us.
Thank you very much, moderator, and thank you for allowing me to be here. It's my first time on this Family TV, and I hope we shall have a fruitful discussion, and our viewers will have something to benefit from this. Yeah.
Yes, they will. Yes, they will. And it's important for us to know what happens when it comes to the judiciary. That's why we have His Worship here with us today. Now, talking about the judiciary as an arm of the state, tell us about the judiciary, what's its mandate, and what does the judiciary do when it comes to our good republic, Uganda?
Thank you very much once again. You have partly distinguished the three arms of government, which include the executive. The executive is headed by the president. We have the judiciary, which is headed by the Chief Justice, and then we have the legislature or parliament, if we want to keep it short and explain it to people, which is headed by the Right Honorable Speaker. So all those three arms of government have different roles that they play, and they are complementary to each other. Each one of them has a role to play, and when you add, then the state runs very well. So on the part of judiciary, we have our mandate, which is provided under the Constitution, and our mandate is to adjudicate. In simple terms, adjudicate means you preside over disputes, where people have a dispute, which can be between two individuals, or it can be between an individual and the state. So you come in between and listen to both, and then you try to come up with a solution for them. So that is our main mandate, and of course we interpret the laws. We do this mandate in consonance with the law by interpreting the laws, whereby the laws include the supreme law, which is the Constitution, and then the other laws which enable the Constitution to be operationalized. So we are mandated with interpreting those laws. The parliament makes the laws. The duty to interpret them lies with the judiciary. So you have seen in some cases where we have said this law is not in consonance with the Constitution, and it has been declared to be unconstitutional and annulled. That is the work of the judiciary. And once that is done, it means that the parliament will go back on the drawing table and make sure that they make a different law, or they improve on that law to make it to make it constitutional, if the court has said it is unconstitutional. Of course, we know the role of the executive. The executive, before a law comes into being, the executive initiates. They come up with an area which requires a law, say in this area we need a law, some areas need a policy. So once they realize that it requires a law, they go beyond the policy and they initiate the process, which is sent to the parliament. Then the parliament debates it and comes up with the law. So you can see that all the three arms have a role they play in all this. This one has initiated, it has gone to parliament and has turned into law, and now the judiciary is coming in when there is need to interpret that law. So you can see that all the three arms are complementary. You cannot have a gap. If you have one off, then it means you cannot operate properly. So they have to be, all of them, operationalized. Now, I said that the judiciary is headed by the Chief Justice. His Lordship, the Chief Justice, is the head of judiciary. And when you look at the order of precedence, which other people may call the most important people in their order, you will find that we have the president on top, we have the vice president, we have the speaker, and then we have the Chief Justice as number 4. After that, if you want to add, you will have the deputy speaker, and then you will add in the deputy chief justice in that order. So you can see that all the three arms are all important. Now, it is headed by the Chief Justice, who at the same time heads the Supreme Court. The Supreme Court is the topmost court in Uganda. It is the last court if you want to appeal. It is the last court you go to, and it is headed by the Chief Justice. Now, below him is the Deputy Chief Justice, who at the same time heads the Court of Appeal / Constitutional Court. So our Court of Appeal, the same court acts as the Constitutional Court. In some countries, they separate them. You find they have a separate court for constitutional interpretation and all that. But for our case, our Court of Appeal does that, so that whoever wants to appeal against the decision they have made can go to the Supreme Court. Now, after the Chief Justice, below, in terms of, now this is a precedence in the judiciary, if we say the most important person going down, the next person there is the principal judge. The principal judge heads the High Court and other courts which are below. These include the Chief Magistrate's Court and Magistrates' Courts. All those are under the principal judge. So the principal judge heads the High Court. All the judges in the High Court are supervised by the principal judge. That is the order. So he's number 3 in terms of our party. When it comes to judiciary, we have the Chief Justice, we have the Deputy Chief Justice, and then we have the principal judge. Now, of course, I have talked about the Supreme Court headed by the Honorable Chief Justice, and it is composed of justices of the Supreme Court. Those are the justices. If you want to use a simple term, you call them judges, but they are justices, and in any matter they sit and handle, and the Chief Justice becomes the head. When they are sitting, is the leader of that team. When it comes to the Court of Appeal, when they are sitting, they sit in panels. Even in the Supreme Court, they sit in panels. If there is any matter, they will sit, depending on what type of matter it is. But they sit in a panel of 3, 5, 7, and where possible 9, depending on the numbers that they have. So they have to sit in terms of an even number, so that they are able to decide a matter by like a vote.
Can you take us through the different matters that apply when it comes to different courts? Which courts handle which matters? Now,
the Supreme Court handles appeals which come from the Court of Appeal. The other matters they handle in the Supreme Court is presidential election petitions. All presidential election petitions start from the Supreme Court and end there. So those are the two categories of cases that the Supreme Court, it handles. Then for the Court of Appeal, it handles appeals which come from the High Court. If someone is dissatisfied with the decision from the High Court, he appeals the Court of Appeal. And the other category they handle are constitutional matters. If it's a constitutional matter, it will start from the Court of Appeal. And if someone is not satisfied, will appeal to the Supreme Court. So those are also the two categories that they handle. And when it comes to election petitions,
constitutional matters being if there's a right under a law that may be seeming in contravention, let's say, of the Constitution, then someone can take up that matter to the Constitutional Court and say there is something wrong with this provision in a certain law.
Exactly. So it has something to do with interpreting the Constitution. There is, you come up and say this article or this section of the law is not in line with the Constitution. I want it to be declared so. So that matter goes to the Constitutional Court and it will interpret it. If you are not satisfied, then you go to the Supreme Court. Of course, all matters that we handle in courts have a backbone of the Constitution, but they are not related with interpretation. We are applying the Constitution. Other courts apply the Constitution, but it's not interpretation. You know, you are saying this section provides that you should do A, B, C, D, and you have not done it. That is application. But when it comes to the issue of whether what has been done or what section of the law has been put in place is in line with the Constitution, it becomes an interpretation. And that can be done by the Constitutional Court. So that Constitutional Court has that, and like I was going to mention, when it comes to matters to do with election petitions of parliamentary, LC5, local council, whatever, all those petitions, once they are lodged in court, the Court of Appeal is the last court. There is no appeal beyond there. You have been seeing most of them recently. We had the petitions which were decided by the Court of Appeal. If you are not satisfied, that is the end. You only wait until another term for elections. You can't go to the Supreme Court. The law does not allow that. Now, when it comes to the High Court, in our laws, we say the High Court has unlimited jurisdiction.
What does that mean in lay terms?
In lay terms, it means it can handle any type of case. You can now come up, for example, you can come up and say, this Kampala Road where it is not where it's supposed to be, and I want to go to court and sue. The court to go to is the High Court. It has that unlimited jurisdiction. It can handle any matter. Any matter can be handled by the High Court. Of course, you have to remove the ones I have specifically mentioned, which the law puts in other courts, like the presidential petitions, like the interpretation of the Constitution. Those two are specifically provided as to where they should go. But the rest of the matters can be handled in the High Court, regardless of how much money is involved. The High Court can handle. So the High Court handle all the matters that can be filed in any court, and it also handles appeals which arise from the lower courts.
Lower courts like the Chief Magistrate's Court.
Chief Magistrate's Court and Magistrate Grade 1. Now, I will try to explain there because someone may think that when we go in our order, if I run quickly through the order, we have said we have the Supreme Court, we have the Court of Appeal, we have the High Court, we have the Chief Magistrate's Court, we have the Magistrate Grade 1. Then there is another grade which we are phasing out called the Magistrate Grade 2. The Magistrate Grade 2 in our case is below the Grade 1. So in our case, 1 is higher than 2. So magistrate grade 2 is below the grade 1. And we are trying to phase that category out, because the magistrate grade 2s, we say they are not professional because they are not lawyers. They only have a diploma in law, whereas the magistrate grade 1 going up to the Supreme Court, these are lawyers. So we are trying to make sure that we professionalize, and all cases are handled by professionals. But what we have done is that we are doing this in a manner that we don't face them at once. But once a grade 2 retires, once a grade 2 dies, we don't replace that one with another grade 2. Instead, we recruit a magistrate grade 1 to take over. So we have reduced them. I think right now they should be around 25, 26 remaining. Those who are per grade and get degrees, they also compete with other people who want to be grade 1s, and they are absorbed. So we have absorbed many in that category. So if I went back to the categories of cases, I have said the High Court handles
any cases, family matters, civil, criminal. Now, of course, when it comes to criminal, we have said the High Court has an unlimited jurisdiction. This is specifically in terms of civil. Civil matters are those cases between an individual where someone's land has been grabbed, you have borrowed my money, you have not paid back, you have supplied goods, they have not paid you. So those kinds of cases are called civil. The criminal ones are those ones where someone has wronged you. For example, we have murder, we have theft. Those are criminal cases. Now, when it comes to criminal cases, we have categories of cases which go to the High Court and those which go to the lower courts. I have talked of an unlimited jurisdiction of High Court in terms of civil. When it comes to criminal, the High Court handles what we call capital offenses. Now, capital offenses, in this case, we are referring to those cases which carry a maximum sentence of death. Maximum is death. Wherever the maximum is death, that matter is handled by the High Court. And these include murder, robbery, aggravated defilement. We have rape, terrorism. We have treason. All those cases are in that category, and they can only be handled by the High Court. That is the criminal cases. Now, when you move down to the Chief Magistrate, the Chief Magistrate, in terms of civil cases, handles those cases where, if you put in the value of what he's handling, they are 50 million below. When it goes above 50 million, even if it is 50 million and 1 shilling, that is beyond 50, that one is now for the High Court. But when it is below, the Chief Magistrate handles. When it is a criminal case, any case where the maximum sentence, if a person was convicted and was to be sentenced, where the maximum is life imprisonment, all those cases the Chief Magistrate can handle going down. That is the maximum going down. He can handle any small case, he can handle anything, but as long as the case attracts a sentence which is not beyond life imprisonment. That is the Chief Magistrate. Now, when it comes to the Magistrate grade 1, the Magistrate grade 1 in terms of civil handles cases where the value is below 20 million. When it comes to criminal, all the cases where the punishment is not life imprisonment, and of course, and also we can talk of death because it is also above life imprisonment. So all those cases which are below that, the Magistrate grade 1 can handle. Someone will say, okay, this jurisdiction of 20 million looks a little bit small, which is very true. And as an institution, we have realized that when it comes to a place like Kampala here, what
what property would be below 20 million. If it is land, a plot of land, the smallest plot of land in Kampala is 50 million and above. So that means most of the cases are now going to those other upper courts, and that is the High Court. And it is one of the causes of delays of hearing of cases, because most cases are above 50 million, and therefore they go to High Court. And when it comes to the number of the judges, we have very few. If you compare them with the magistrates or chiefs, they are very few. And
we are going to get to the discussion as far as delay, case backlog is concerned, and as far as the limited number of judiciary officials is concerned. But now that you've taken us through which court handles which case and the judiciary system as a whole, take us through now court process. Now, I don't know which one's more comfortable for you, if you're going to come up with a criminal or civil case, but take us through the different court processes. When should a person go to court?
Thank you very much once again. We have looked at which courts and which handles what. Now, if someone has a case, it can either be criminal or it can be a civil case. If it is a criminal case, it is expected that one of the things I normally use is that a state, which is Uganda, is supposed to protect its citizens. That is its duty. It must give me security. If I'm sleeping, I should sleep without any disturbance of a robber or someone. If I'm moving at night, I should move freely, because that is the duty of the state. We pay taxes for it to perform that duty. Now, if anyone has wronged me, then the state must come in to look for that person and punish that person on my behalf. I should not get my spear to go looking for the person who has wronged me myself, because the duty of the state is protect me. If someone has sneaked and escaped their eye and has done it, it again becomes their duty to look for that person and punish that person. So that's why, if it's a criminal case, I must go to report to the authority, and the authority of the state.
That's the police.
That's the police. So if someone has stolen my bicycle, I will go to police, because the state had a duty to protect my bicycle from being stolen. It has been stolen, so I report. Now the police has the duty to investigate and look for the what? For the culprit. Once they have arrested him, of course, when I report, I make my statement on how the bicycle was stolen and from where. Now they will arrest the person, he will also make his statement. They will either have recovered the bicycle or not. Now, they can't punish the person themselves. They have got to take that person to another institution with the mandate of doing that, and that is the judiciary, that is the court. So they will process their case, and once they are convinced that there is something that should be taken to court, they first take the file to the state attorney. The state attorney, who is under the DPP,
that's the Director of
Public Prosecutions, works with police in as far as investigations and prosecuting of these cases are concerned. The mandate of the DPP is to prosecute. Once the police has investigated, DPP comes in and prosecutes. So they work hand in hand. So once the file is ready, they will say, for us as lay people who are police people, we have investigated and done our part. Can you look through this file and see whether what we think is the offense is the offense? So the DPP employs lawyers, so they know the law. They will look at the law and look at what the police has gathered and see whether it is worth going to court. Once they are convinced that this is worth going to court, they will now bring the suspect with the file to the court which takes that area where the offense has allegedly been committed. Now they will come with the file. We have our court there. We have our staff working there. They will receive the file, and we have registers. So at our courts, we keep registers of different types. We have criminal registers, we have civil registers. When it comes to civil, we also categorize civil land, civil family, civil commercial, where someone has lent money and has not paid back. So we categorize those civil cases. So they will now register the case in the criminal register. And once it is registered, they will take the person before the judicial officer, the magistrate, who is mandated to handle the offense, like I have explained, who has jurisdiction. If it is a capital, whether it is a non-capital, they take that person according to the type of offense. Now the person will be taken before that judicial officer. The judicial officer will read the charges, the allegations.
To the suspect.
To the suspect. We call them allegations. This time they have not been proved. They are saying, this is what they are saying. What do you say? So that is what we call plea-taking. The person reads the charges and says, it is alleged that on Friday at this bar, you stole so-and-so's phone. And it was got with you. What do you say? So now it is upon the person to say either it is true, I stole the phone, or I did not. If he says I stole the phone, it means he has accepted. He has cut the story short. The judicial officer will convict him and give him the punishment that is appropriate. Of course, a person who has pleaded guilty, who has accepted without wasting time, will get a lesser punishment than the one who has taken the whole process up to the end. In Uganda, there is a saying that there is something that is called when you have accepted, akiriza aluwa bitono. Okay? If you have accepted, you pay less than the one who has refused, because you consume time when you refuse. We have to bring in witnesses, we have to take our time which we would have used for other things. So the person will give him his punishment there and then. Either it will be a fine, pay a fine of so much and give him back his phone, or you are going to prison for 2 weeks or 1 year or whatever, and the person will now go to serve the sentence. That is when he has accepted. If he has not accepted, the person will record that the person has denied. And that means now the state, which means the police and the DPP, must now look for what? They have to bring evidence before the court to show that this person committed this offense. So the person will now either be granted bail on that day, or if he cannot be granted bail, he will be sent to prison and given a day when he has to come back to court. And on that day, when he comes back, if the police says, the police and the DPP, they have indicated that they have done inquiries and they are ready, he will come back for hearing. It is expected that when he comes back, the DPP and the police will have their witnesses and evidence ready to start the hearing of the case. If they are not, they ask for time, and the case is adjourned, and the person is either now granted bail, or he will again be remanded. So the process will continue until when they have evidence, and then they can present it, and the case is heard. If the person has not been granted bail and is in prison, the law gives a certain period of time when he should be in prison, and that is 2 months. The law is that if it is a non-capital offense and no bail has been granted, no evidence has been brought, the person should spend 2 months on remand. And if they have not brought evidence to hear the case, the court has the mandate to grant that bail on the person, whether the person wants the bail or not. It is a duty of court to give him bail. And I think the framers of the Constitution, what they had in mind is that after the 2 months, and you have not gathered the evidence you need in a non-capital offense, the person should get bail, because it means you might not have evidence at the end of the day, and the person will have spent a lot of time in prison for nothing.
For no reason.
So let him be out.
That's very good. Thank you, His Worship. But very quickly, in a minute or less, because you've described as we prepare to get into a quick breather, what is the civil procedure now? Very quickly, and how is it different from the criminal procedure?
Now we have said that the criminal one you have start from the police, and then it comes through that process. Now for the civil, which is between you and an individual, the two of you have an issue, or you have an issue with the state, you go straight to the court. You don't go to police. When it is civil, you go to the court, and when you are choosing the court to go to, you use the perimeters I have given of the jurisdiction, of what kind of case do you have. Is the person you are demanding money from, is it above 50 million, where you have to go to High Court? Is it below 50 million but above 20 million and you have to go to the chief? If it is below 20 million, I have to go to a court which is a magistrate grade 1 court. So some can afford lawyers, others cannot. If you can afford a lawyer, it means you have engaged a lawyer who will now know what to do, because he's a lawyer, he knows the legal process, who will prepare what is required, and then he takes it to court and it is received. If you don't have a lawyer, you will move to court. Now when you come to court again, we have, like I explained, we have different categories of cases. We have what we have called small claims, if it is a case of money. And then we have that other component which is not small claim. Now if it is small claim, we have simplified that one. Come to court and say, I lent so and so 10 million or less, because small claims it must be 10 million and above and below. They will give you forms and say, help you to fill the form, and you will have opened your case, and they register it. Of course, you have to pay some prescribed fees, which is supposed to be paid in the bank. They will tell you, for this case, you pay 20,000 shillings, which you will go to the bank and pay and come with a deposit slip. Your file is opened. They will give you documents to go and serve the other party to know that you have taken him to court. Once he receives also, he will say, okay, this man has gone to court, fine, I have my defense. He will also come to court and put his defense. Now the file will now be ready for the magistrate or the judge to adjudicate, to listen to both parties and come up with a certain position.
Wow. I know that this time is the problem, but I know this is a very interesting discussion, because we are now learning what the role of the judiciary is and how to institute a court process. And I know so many of us have questions. That's why we have the opportunity to hear your questions and to respond to your comments. Please send us a message on WhatsApp, on our WhatsApp number. That's 0787 447 684. 0787 447 684. And His Worship Jamson Kalemani will tackle your questions or queries and your comments. But for now, let's go in for a sip of coffee, after which we shall come back to continue with the discussion on the judiciary and the challenges that the judiciary is facing. But we shall also hear the comments and the questions you have for His Worship.
Issues at hand on Family TV. Enriching lives.
This is Issues at Hand on Church of Uganda Family TV, and we are happy that you are joining us. We are having a good discussion on the judiciary, the role that the judiciary plays, and what to understand concerning the court process, how it all works. I know a lot of us have questions. What happens in court? How can I institute a court proceeding? Who institutes a court proceeding? And before the quick breather, His Worship Jamson Kalemani, who is my guest on Issues at Hand today, took us through which courts have which jurisdiction and which courts handle which cases. And this time, it's time to hear your comments and queries. Of course, if you have any comments or you have any questions for His Worship, please send them out to 0787-447-684 and we shall address them. But right now, my guest, His Worship Jamson Kalemani, please, the question of challenges, and there are many challenges that happen. I always hear one of the biggest challenges is case backlog, where some cases take long to end because maybe the justice system is overloaded with so many cases, and you had already started sharing us some of the challenges that the judiciary system is struggling with. So please enlighten us on these challenges and what is the way forward as finding solutions.
Thank you very much once again, and our viewers, thank you very much for being there to watch this program. I have explained to you the different courts that we have, and what we have to note is that these courts are manned by human beings. It's human beings that decide the cases. It's not computers, it's not machines. So we need human beings to decide these cases, right from the Supreme Court downwards. Now, one of the challenges that we have is limited human resource. In the Supreme Court, our target or our structure has a total number of 20 justices. That is what, if we were to appropriately serve, in as far as the Supreme Court is concerned, that is the number that we require, 20 justices. As we speak now, we have 10. Including the Chief Justice, who is the head of that court. So you can see that we have a shortfall of 10 justices. That means the simple calculation I normally do is that if you have 10 and you are supposed to be having 20, it means one justice is doing work of 2. Is now covering up for the other justice who is not there. When it comes to the Court of Appeal, stroke Constitutional Court, our structure provides for 56 justices of the Court of Appeal. That structure indicates that the people who calculate economically and they feel that if you have 56 is when you will serve these Ugandans who are now coming to 45 million better without delays. But out of the 56, we have 15. Now, 15, if you put in a calculation, it means one justice is handling work of like 4. He's handling the work which would have been for 4 people. Now, if you are doing work of 4 people and you are 1, it means you cannot be efficient.
So what is the judiciary doing to counter this problem?
So, and that continues from up, down. It goes up to the lowest level. What is it doing? What it is doing is that we are happy that at least we have been agitating over time, and we seem to get some positive responses. I said the other arms of government have a role to play on our part as well, because that structure we are talking about was approved by Parliament. It's not us who come up and say we want this and this is how it should be. No. We propose and they look at it and they say you are right, and they approve it. So they are the ones who approve that structure, first of all, which is very good, because they are agreed with us that we need that number to serve well. And the next one is how do we get those people? So we have been provided in phases some resources to recruit and have those numbers. So what is happening now is that at least every financial year we are getting an increment on the numbers. We keep adding a few, because we can't have them at once. If you want 56, we cannot wake up and have all of them at a go, because it is costly. So we, in agreement with the other arms, that we can have them in a phased manner. This year, adding, if we are 15, give us 5, they become 20. Next year, let's increase 25. And maybe in 5 years, if resources permit, we realize the number of 56. So that is what is being done. we are getting them in a phased way. The other sources, of course, required, there are other sources like financial sources which are required. Our budget has had to be increased in the financial year 2020-2021, we were at 119 billion. And the financial year 2021-22, it increased to 390 something. So that means it like tripled. And that's why the numbers I'm talking about are being realized. Recently, we got 144 magistrate grade ones in one financial year, and yet in the previous ones would be getting 10, 5, 12. So getting 144 shows you that it's a big boost. So to me, I think we are on the right track. If we continue in that direction, we shall see that issue you have talked about of backlog, which is our biggest thing. It will be realized, and once you deal with backlog, there are so many things you solve. One of them is corruption. People think cases delay because people want money. You are not hearing my case in time, you want me to influence you. Yet the person is overwhelmed by the work. So once the system becomes efficient, a case comes in 2 months, the person is out of the system. He gets his justice. He will never think that the system can ever be corrupt, because he has gotten justice. But when you delay him, he's moving up and down all the time, he gets disgusted. And what does he think? Maybe I need to do something for my case to get out of the system. Yes, if you get a small-hearted person, might be influenced by that. And even, by the way, the case might even get out of the system after that influence. And all that is caused by those limited resources, and the delays, they lead to someone thinking they need something, and that is corruption, which can be perceived or actual. Both of them exist, actual and perceived.
When it comes to the issue of resources, I remember sometime earlier in this year, people were up in arms about how much it costs to dress some of these justices. I don't know what you have to say to that. And some people were saying maybe we should go back to, maybe we should get rid of such colonial cultures in which our justices dress up with such expensive attires, and they can reallocate those resources to important things like you were mentioning, getting more magistrates on board and resourcing the judiciary.
Very true. Of course, we have those dressing, the attires and the like. But to me, I think the attires are not the issue. It's not the issue. Even if you look at the amount of money we are talking about, which they cost, even if you channel it, it may not be a solution to what we are talking about. It may be a small component. And of course, what we have got to understand is that even the lawyers, they have their dress. They put on those gowns. I am on a Church of Uganda television. The bishops have, when you meet a bishop, you know, I have met a bishop. If you meet a reverend, this is a reverend. But if you say they dress like you, like an ordinary person, and they are also mingled up, when shall we accord them their due respect? And when shall we believe in them? You know, believing in someone, you must have that respect, and he must be distinguished. If you just mingle with anyone and is ordinary, then you will not give him that, he is not distinct, and then you may not give him the due respect. And even what he does, because the respect you give a reverend is a different respect you give a bishop. And they are distinguished by the work they do and how they dress. So the same way, the dress shouldn't be an issue. I think what we all need to do is to improve on the service delivery. Let's be efficient. The rest of the dresses will not be an issue if we are doing our work very well.
That's true, and that's why we come here on Issues at Hand to address some of these issues. Now, talking about addressing issues, we have comments that are coming in onto our WhatsApp line, and I know that you are going to address them eloquently and adequately. Now, we have a comment coming in from Mukasa George, who is from Kawempe. He says, "Thanks Family TV for today's guest. I am Mukasa George from Kawempe, and I would like our good guest to differentiate between a policy and a law. So what's the difference between a policy and a law?
Okay, thank you very much. Now, when there is something that is going to be done by the government, they just wake up and start doing it. There must be guidelines which are put in place on how to do it. An example is I can talk of the parish model. It has things which have to be put in place for it to be implemented. Now that is the policy. You have to have a policy on it. Who is going to do what, and what is required? All those things are found in a policy. So when it is supposed to go beyond a policy, you can say we have a policy, but it requires ABC. Supposing someone does this, how do we address it? If he does a wrong thing, how do we deal with it? Now, a policy is developed into a law. So all these laws we have, most of them begin as policies, but they feel that the policy may not be enough. It should be actualized into a law. Now the law is crafted out of that, and then it is taken to Parliament, and then it is made a law. A policy may not necessarily go to the Parliament. It can stop at the cabinet level, and it operates, and it is going to be implemented. But when it comes to a law, it must be taken to Parliament.
Thank you for addressing that. Then Brian Kavuma from Ginger says, good morning, His Worship Jamson Kalemani. Can you please talk about the court-martial? Where does it fall in the order that you have just explained? Thank you.
Thank you very much. There are several other, I've talked about, the ones I've talked about is what we call the courts of judicature. Those are the ones I've mentioned. But there are other subsidiary courts which do work but are not under the courts of judicature. Some of them can be disciplinary committees. We have the tribunals. You have heard of the tax tribunal. You have heard of electricity, whatever tribunal. So we have tribunals. They are also established by the law, but they are not courts of judicature. And people who sit in them are not judges. So a court-martial, I would equate it with because every institution has a disciplinary mechanism of its people. So police has a disciplinary mechanism. Even as judiciary, we have our disciplinary committee there, which deal with us as judicial officers. Now, the court-martial is in that category for dealing with military. That is the court-martial. Now, all these subsidiary courts, when you are not satisfied with what they have done, you join our system. And you join our system at the level of the High Court. That's why you connect to our system. They have done, they can even start from smallest disciplinary unit, like for example, the army, you'll go and find that they have a disciplinary at the level of a barracks, level of whatever. Then you go appealing, and then you end up in the court-martial. When you are appealing the decisions from down, when you reach the court-martial and you are not satisfied, you connect to our judicial system through there. There is another court. This one is a court because it is called industrial court. Industrial court has 2 judges there, and they sit with ordinary people to decide the cases. So that one is at the level of a high court, because when someone is not satisfied with their decision, we'll connect to the court of appeal. So that is the court-martial. The people who sit there are not necessarily, they are not the judges that are the ones in the courts of judicature. But what they do is also provided by the law, and it is a legal process.
Thank you for addressing that. Then lastly, hello Family TV. Thank you so much, His Worship. But do we still have the death penalty as one of the punishments in the penal code? We hear that it was abolished by the president. That's coming in from Namatovu Josephine.
Now, death penalty, death penalty is in our laws. What happened was, initially, we had it as mandatory. Meaning, if you committed an offense where the maximum sentence is death, it was the only penalty that could be given. An example, if you have been convicted of committing murder, the judge had no option. He would say, there is only one sentence, which is death. And I hereby sentence you to death. Now, that sentence was challenged by one of the prisoners who was on a death row. Death row means they are convicted, they are in prison, and are waiting for a day when the president is the one who signs. The day for him to sign and say, this one should be executed, you are killed. So one of them who was waiting, and that is Chugura. That lady was among the people who were waiting for that sentence. She, with the help of some human rights activists, she filed a petition in the Constitutional Court to challenge this death penalty, saying it is not supposed to be on our laws, it is inhuman. So it was filed as a petition. It was handled by the Constitutional Court. An appeal even arose from it, went to the Supreme Court, and it was agreed that death sentence should not be the only sentence a person should suffer. It should only be a maximum sentence. So it is in our laws, but a person can be given any other sentence other than death. If you have committed murder, you have committed aggravated robbery, and they have found that you did it, you have been convicted, there are option sentences they can give you other than murder, but they can also give you murder if you deserve it. So it is still in our laws, and it has never been scrapped. And what I have explained also, it was not done by the president. Like I said, we have laws we play. It is now the judiciary which declared so. So it is not the president that said no more death sentence. It is the judiciary, but the sentence is there, but it's not the only sentence a person can be given.
Maybe when it comes to that discussion, what the president did, the president has been pardoning some people who are on death row. And so that's maybe, which is a constitutional mandate.
Yes.
Yes, definitely.
And I think that is one of the things which many people misinterpreted the Chief Justice one day. The Chief Justice, because the president, you can sit as a court and hear the case for 30 years. And at the end of the day, you say this person is sentenced to death. You cannot execute the person. The person to sign the execution paper is the president.
The president.
Now, in that case, he becomes the final person, doesn't it? And it is a constitutional provision. He's the one who will say, this person, despite how many years you took to try him, I have pardoned him. Or I am not executing him, I have forgiven him. So in that case, he becomes the final person, above even the Supreme Court, which has decided the case. He's the one who has come and said, I have forgiven you.
And talking about final things, His Worship Jamson, I would like you to give us in 30 seconds your final remarks on the judiciary, its role, and any last word you'd like the viewers and the public to know about the work of the judiciary.
What I can say is that, yes, we, as an institution, we are not perfect. There are so many things we may not be getting right, and we have to be judged as human beings. These courts, the people who sit in these courts are human beings, you and me. Even you can be a judge. You are a human being. So sometimes we may not get things right. That's what the context should be. We should get it in that context. Where we have not got it right, guide us to get it right. But we are doing all we can to make sure that we serve the Ugandans very well. We are doing all that we can to ensure that there is no backlog, and Ugandans deserve a quick judicial system because it has a lot it plays. We have not touched so many things. What is the role in economic growth judiciary plays? If you have a land dispute and it takes 30 years and it's for an investor, how much money have you clogged there? How does the investors get attracted to a country where the judicial system is not moving. They can't go there because any dispute will take 30 years. How about my money in the bank? So there is a lot that we have not touched, and I hope that I will have another opportunity to come and we discuss more.
Definitely. Yeah. But thank you so much for being on Issues at Hand today, and for taking us through the role of the judiciary and taking us through different things like court processes. So that was His Worship Jamson Kalemani, who took us through the role of the judiciary. Now, as a family, please, it is important that as parents, as husband, as wives, but as children, we know what the law says about going to the court. In case you have been wronged as a family, you now know the different courts to go to and the different jurisdictions that come from the different cases. So it's important that you take this issue seriously and you go to a court in case it's a civil case and you have a dispute. Let's say if it's finances, if it's land, and then if it's a criminal case, you go to the police and they will institute a case with the DPP. So be blessed and love your neighbor. That's very important. And parents, love your children. Children, love your parents.
The views expressed on this show are not necessarily those of this television or its management, but as of individuals as we hear them. Family TV, enriching lives.